So in the previous lesson, what we did was spend a bit of time talking about really what equity is as a concept. And I noted that at the end of that lesson that you can really fundamentally suggest that in order to have a better understanding, in order to have the best understanding of what equity truly is, we should really look at its history and how it's developed. Because we can say, until we're blue in the face, that equity, it rounds out the sharp edges of the common law. It is associated with the concept of fairness derived from the Latin word aequitas from the Roman law. But really, where does this develop and come from? Well, that's what we're going to do in this lesson, and as with the other lesson, this is part of just a bit of introductory content for the SQE specification. And like I said, the previous lesson, should I say, examined the nature of and the delineation between the concept of equity and the idea of the common law. This lesson is going to spend some more time examining the historical development of the idea of equity in brief. This could be a 1-hour lecture if you really wanted it to be, looking at the history of equity. We're going to be examining basically 1,000 years worth of history in the space of 10 to 15 minutes. So the history of equity, the story of equity, shall we say, can be explained with reference to the legal system, the system of legal adjudication in the early periods of English history. That's the best way in which we can describe it. The way a claim would be brought when thinking about this very early period would be through a system of things called writs. A writ is simply a formal order which is issued by some kind of judicial body or maybe an administrative body of that kind. And a royal writ, the royal writ system, would be limited in the sense that a claim would have to be brought which corresponded with the particular writ in question. So this would therefore limit the number of remedies which are available to at any one time, depending on the case. So the type of writ, a particular writ, would limit the type of case which could be brought. And then things start to develop in 1258, because essentially what this results in is something known as the Provisions of Oxford, which were a number of constitutional changes which developed out of the Oxford Parliament of 1258. The provisions themselves were established essentially as a means to resolve a particular dispute between the king at the time, who was Henry III, and his barons. This means that the provisions of Oxford were acted in a similar way to that of Magna Carta from 1215. Now, one of the things that the provisions, of Oxford had done was in fact limit the number of writs that could be issued by the king. This was seen initially at the time, or could be seen from a historical perspective, as potentially a symbolic indication that the common law, which of course was not so limited as the provisions of Oxford provided, that the common law was potentially supreme to the whims of the monarch. And while the provisions of Oxford would ultimately be revoked as the result of the Second Barons' War between 1263 and 1267, these administrative changes would mostly stay in place and would ultimately be reconfirmed in 1267 with the Statute of Marlborough. Now, this is giving us an indication that there are two different things that are going on here. There are two different legal systems, if you will, that are existing here. You've got the sort of royal writs system that is taking place under the auspices of the royal prerogative, the prerogative of the king, and then you've also got the slow and eventual development of the common law, which doesn't seem to be as connected to the idea of the king or the whims of the monarch as this system of writs that has now been limited by the Oxford Parliament. Things start to get a little bit more institutionalized, shall I say. They become more practically institutionalized as the result of the establishment of the Court of Chancery. So the Court of Chancery didn't do that much in terms of the changes to the administration of justice, because the actual law as applied would be the discretion of the king on application of the law to his subjects. What the Court of Chancery did, though, was institutionalize the process. So essentially, as more and more cases would come to the king, the king themselves, who at the time was Edward I, would have to delegate this responsibility to their chancellor. Now, because there's so many cases, of course, the king couldn't see all these cases, see all of these cases and decide on all of these cases. So he delegated that responsibility to his chancellor, or some of that responsibility to his chancellor. And his chancellor, in turn, would establish a fixed court that was the Court of Chancery to hear these claims. Now, one of the reasons for this is because the king travels around the country. And if the king's travelling around the country, then the chancellor would be travelling with them often at times. And so they might hear cases from around the country. But it would mean you wouldn't necessarily know exactly where the king was at any one time if you had a grievance that you would like to have heard. Whereas instead, if you had the establishment of a single permanent Court of Chancery, then everybody knows where it is, and then they could go to that Court of Chancery and they could hear their cases by the Chancellor. Evidence of the Chancellor of Edward II from the records of the Parliament of Lincoln in 1315 shows that the Chancellor would even delegate these issues to his personal staff, who were the Chancery. So there would eventually get to be so many cases that the king delegates the cases to the chancellor, who in turn would have to delegate the cases to his personal staff, who were in the chancery. And so the Court of Chancery would find a fixed location under the reign of Edward III in Westminster Hall. This served, like I said, two purposes. It institutionalized the Court of Equity, and it made for ease and simplicity, since historically the Chancellor would have to travel with the King, making the administration of justice a difficult task. So as I mentioned on the previous slide, there were practical reasons why we should establish a Court of Chancery that didn't move or didn't go anywhere, in order to have people hear those cases there, rather than them having to try and find where we are in England. Because fundamentally, at this time, there's no social media, there's no phones, there's no television, there's no anything like that. Most people don't even know what the king looks like at this time. Most people, which is why you can have so many pretenders and people who claim to be X, Y, Z person in order to stir up rebellions. Henry VII was particularly familiar with that particular concept. So, because of that, and because you don't know where they are, and it could take weeks travelling around the country, they might not even know where they are really, that it would be almost impossible for administration of justice to actually take place. Whereas, if you've got an established Court of Chancery, that becomes familiar to people, and then they can bring their cases there. The Court of Chancery then would attempt to avoid conflicts with the common law insofar as they would arise. This sometimes happened, and this sometimes didn't result in the avoidance of conflicts. We'll get to that in a second. But fundamentally, for the most part, at least early on, the Court of Chancery tried to remain and not deny the existence of the authority of the common law, and so essentially situated itself as subsidiary to that of the common law. It instead responded to the consciousness of the individual and individual cases. But this is not to say that there weren't any conflicts at all. Fundamentally, under the reign of James I, so we're skipping quite ahead here to 1603 to 1625, which is the reign of James I, there were conflicts that existed between the Lord Chancellor, Lord Ellesmere, and Lord Justice Coke. For those of you who don't know much about British history or English history, obviously the reign of James I marks a quite tumultuous period in English history. The Stuart dynasty, which of course came from Scotland as the result of the merging of the two monarchies after the death of Elizabeth I in 1603, we see the increasing conflicts start to exist between the king, who is operating under the royal prerogative, and James himself, who saw himself as a divine right of king. He had the divine right of kings, and an increasingly politically conscious parliament that is growing separate to that of the monarchy, and not necessarily too much under James I. There were a lot of conflicts between James I and his parliaments, but mainly under his son James II, who takes the throne in 1625. Charles II Charles I in 1625, that we see major conflicts that result in the outbreak of the English Civil War and the regicide of Charles I and the establishment of a republic under Cromwell. But the conflict that existed between Lord Ellesmere and Lord Justice Coke essentially begins with the assertion by Lord Justice Coke that the Chancellor's issuance of injunctions under the basic principle of equity were unlawful. The two would attempt to challenge the decisions, each with a number of different cases. The case, for example, of Courtenay and Glanville, both institutions oversaw the jurisdiction, with Lord Ellesmere dictating that Glanville should be imprisoned and Lord Justice Coke demanding that Glanville be released. So this was an example where you have a case that is involving the Court of Chancery and the ordinary common law system, and they are in disagreement with each other. One thinks that this person should be imprisoned, the other person thinks that this should be released. A similar issue would take place in the Earl of Oxford's case. And so when Ellesmere thought, well, okay, this is getting a bit ridiculous, we need to resolve this matter, we can't be issuing two completely contradictory judgments through our different jurisdictions, so Ellesmere appealed to the monarch, who appealed to James I. The case was referred to Francis Bacon, who was the Attorney General, who favoured Lord Ellesmere in this case. So in this instance, the Lord Chancellor prevailed over that of the common law. Things would continue a little bit like this, a little bit tense, a little bit hostile, but then for the most part, mostly cooperating until we get the question of fusion. Skipping ahead to the Victorian era, we start to see the popularity of the idea of fusing the common law and the equity courts. Why don't we just have them all together and just merge the idea of equity and mix it in with the basic principles of the common law? Well, in 1873, Lord Chancellor, the Lord Chancellor Lord Selborne issued the Supreme Court of Judicature Bill, the first Judicature Act, which was then followed and amended into the Supreme Court of Judicature Act of 1875, which is why we say that there are two Judicature Acts. There's the one from 1873, and then there's one from 1875. Essentially, the latter statute just makes some basic amendments to some of the provisions of the earlier statute. At this point, then, the Court of Chancery would cease to exist, and all new courts would be established having existing dual jurisdiction between common law and equity.